will exchange seats? De wisselen van stoelen voordat jij kan presenteren. Ik denk dat de panelleden gewoon kunnen blijven zitten. Ja, ik denk dat sommigen staan. Ja, ja. Dus als jij het gewoon zo introduceert, dan neem ik het zo. Ja, perfect. So, Sabine? Yes. So, good evening, everyone. My name is Jacob Gilte. I am the director of the Paul Scholten Center, and it is my honor tonight to moderate this session. The Convention and the Kingdom, that's why we're here. Last week, November 4th, was the 75th anniversary of the European Convention on Human Rights, and our colleague, friend Wiebe Hommes, has written a book on the Dutch influence on the creation and further development of this convention, boomerang back to the Netherlands. And in a minute he will present his book, giving us the main tenets of it. After that we will have comments on the book, questions to Wiebe from Antoine Fauché, Professor Antoine Fauché, professor of the University of Paris 1 Sorbonne. We will have Lynn Hillary, who is an assistant professor of Europeanization of constitutional law, I have to say, and Sabine Meyer, who is an assistant professor of European law. After that, I might, if you're lucky, I might have one or two questions myself to Wiebe or to the other panel members, and after that we will certainly revert to the Q&A with you, the audience, and let's hope for interesting and good questions and an interesting and good discussion, which I am confident of. So without further ado, thank you very much for coming. Wiebe, the floor is yours.
I want to get something out of my eye, which is always happening at the most opportune of moments. Thanks. I'll be very brief in introducing this book, just to give you the main tenets of what it is, where it comes from, and what we can take from it. Also to allow for as much as discussion, Q&A as possible. So, also to Jacob, if I go over 10 minutes, I don't think so, but just stop me. I have a tendency to get carried away, but let's not do that. Does this work? It does. So, this book is the outcome of research of quite some years, which began in 2017 or something, when I was very much interested into the history of human rights, which was a booming field at the time, but it was very international. And I was wondering, why is there very little on sort of this broader history of human rights in the European context? And that was a question which ultimately led me to my PhD research at the University of Amsterdam. And the initial idea in one of the first meetings I had was to do this kind of story of the Netherlands, European human rights, which consisted both of the European Union system and the European Convention system. And my supervisor said, well, that's a bit much. Marcus in the room may not remember. But the first sort of instance was to cut down on half of the entire initial proposal and just focus on the European Convention. Hence the focus on the Convention. I would like to do three things in this very brief talk, which is to highlight one particular theme of the book, so the kingdom, which I'll get back to in a minute. I would like to shed some light on interaction as a theme and changes of meaning as a third point, so bear with me. I've always been told never to judge a book by its cover, so I hope you won't do that as well, but this is the cover image of the book, which is printed very nicely. It has a text on top of it, but there is a story to this, and it relates to this first element of the kingdom. Because this is Misty Sea by Jan Torup, so you can see the sea right sort of at the end of the painting, where it's sort of it's an archetypical Dutch landscape in a way. It's Katwijk aan Zee. But Jan Torup is not Dutch. like sort of die-hard Dutch. If you take a look at sort of who he is he was born on Java in Indonesia, and I think it's part of a general theme which runs through the book, that to study law, European law, constitutional law of the Netherlands, you need to take into account that the Netherlands isn't just the European part, and even these sort of perennial Dutch landscapes are different when you view them in the context of the kingdom, which the Netherlands is. It's a kingdom of the Netherlands, which includes the, as they were called, the overseas territories. And I think it matters. Not just in terms of that these areas, they have their own agency, they have their own saying on what they want to do with European human rights, but also in terms of continuities in the convention system as such. And one of the most visible examples, and I always show that, is this is how we usually remember judges from the European Court of Human Rights. So this is Frederik Marie van Asbeck. He is the first Dutch judge at the court. And here we see him in kind of this expertise setting. The European Court was slightly less modernistic than it now looks, but I mean, the bag, the papers, this is how we envision judges. You could still smoke indoors, those were the days. But this is him in a very different context. So here we see Van Asbeck, who's on the right here, standing next to Generaal Spoor in the Indonesian War of Independence. And I think these connections matter to flesh out, to bring out, because this has an impact on how the convention functioned in many ways, but also in terms of the contents of European human rights. There were many things not included precisely because of the colonial dimension. Migration is a great topic where free movement was very much seen as a threat because, well, migration was within empires. And it's no coincidence that migration as a topic under the convention only, well, emerged after decolonization primarily had happened. And when sort of these first cases against the UK turned up, it was about migration in the realm of empire. So I think it matters to take this broader outlook on European human rights in the Netherlands as not being in the sort of European Netherlands, but in the kingdom as such. Moving on to point 2 and 3, so this is the general theme of the book, that we need to look at all these different elements, is that there is a central puzzle at the heart of the book, which is a remarkable rise in human rights law. And this is a graph I stole from a colleague, Mikaras Madsen, who has charted the sort of amount of judgments delivered by the European Court of Human Rights. And we can see it begins very slowly. So 1968 was a very busy year with 3 cases in this first sort of 10-year trajectory. It kicks off slightly in the 80s with 32, so you can see this market development, and then it really kicks off, obviously, in the new system into the 2000s. But then sort of the question I had, and that's sort of a key driver of this research in many ways, is how does this happen? How does European law, how does human rights law come into reality, really? And I was a bit frustrated by the usual explanation, which is still very current in these debates, that this is a Sleeping Beauty story, where you have something, sort of a princess lying dormant, waiting to be kissed awake, and the prince is usually the European Court of Human Rights itself, which in a very top-down way gets a living instrument doctrine going, which really gets this European human rights revolution underway. And I kind of disagreed. And that's what this book is very much about, that sort of, it is not just a top-down story of a European court setting in motion a revolution. It's a much more diverse story. And this brings me to the point of interaction. The interaction between the domestic and the European system, I think, is vital, and I would like to highlight 2 key actors here, which is the state itself. If you look at the state, it is a vital part in the entire sort of human rights ecosystem. So the court, to move back to the sort of revolutionary of the 70s, was allowed to do so, in fact, encouraged to do so by the states themselves. The court emerged as an answer to political struggles within the venues in Strasbourg, where the ministers themselves got into fights on how they would deal with certain cases. So they thought it's quite nice to have an independent court saying something on this. So the states are vital in that element. The second part, or second actors I really like to flesh out are academics. Academics have been at the forefront of many of these developments, be it in migration law, be it just in general with spreading knowledge on the convention and how it could work. Human rights were a very, I would say, forgotten field in the early 70s. Only a few people did it and they weren't taken seriously. Using the convention in court cases was considered, thank you, basically, it was a sign of weakness. You didn't really have a real case. It's academics who are on the front of changing this and making it into a credible legal field. Finally, as these different actors engage with human rights, their meaning changes. So it's not that in this first period human rights didn't matter. Their meaning was significantly different. It was a colonial setting. European human rights were very much for Europeans, not human rights as such. So those changes in meaning you can chart by taking a sort of chronological approach, where what we have now is very much a sign of the 90s. So the system we now have is a 90s system in a way. That has implications for how we deal with current challenges to the European Court. Pushback against the European Court, I would say, is a hugely important theme. We'll maybe get to that in the discussion. In particular because it buys into this story of a court overstepping boundaries, a non-consensual kiss. I think if you take this work seriously, it's much more complicated than that. It's not just the court, it's a lot of actors in society making this into reality. I'll leave it at that and looking forward to the comments. Thank you.
So thank you very much, Wiebe. First panel member is Professor Antoine Fauché of the University of Paris. You may stay seated if you want, or you can, yes. Then I have to make a little room. Yes.
Avoiding to fall.
Yes.
Okay. No. Thank you. It's okay. Okay, so hello everybody. Thank you, Wiebe, for proposing, for offering me to engage in the discussion of the book. I'm all the more happy that I remain a little bit frustrated from the very dense ritual of Dutch defense, which allows very little discussion or speaking from the jury members. So I kept a little notes from that from that moment, which I had only the possibility to raise one question. So. No, I mean seriously, it's really a pleasure. It's really a book that I recommend to a lot of scholars and students and wider public. For one reason, I would say, is that it is a very lively story of law. It's a very lively story of law and of human rights, for that matter. Because it has the richness of material, of empirical material, which is very rare, and documents also that are extremely interesting and striking, and well, I don't think there are pictures. These ones would fit very well, but there are biographies of these people. So it's really law with human flesh, I would say. It's law with drama. It's law with a lot of anecdotes also, but not in a purely strictly historical, but always with a purpose and with a strong thesis that you've mentioned. So I would say that it can speak to many publics. It can speak to historians. It can speak to political scientists interested in Europeanization. It can also speak, of course, to to socio-legal scholars. So, I mean, for that thing, I think it should and it will probably fit in many bibliographies for classes of a variety of public. I don't know about the general public, but this is, but we'll see. With such a nice cover, though, it has all its chances, I have to say. So that is, so it's, and at the same time also, and that's maybe why it also may be of interest to a general public, I think it's not only a book about the past, it's certainly a book about the past, but it's also a book about the past that gives us a compass, in a way, or an analytical frame, if you want, to understand the current context, the current retreat or backslide, if you want, of human rights, of European human rights. For, I think, two essential reasons. First, because it shows very clearly that the fate of European human rights is not only a matter of court. You know, lawyers often have a tendency to tell court-centered narratives where, you know, you have the big decisions and you tell, you know, one after the other. And here, by the mere fact that you multiply sites of observation, it's the Ministry of Colonies, it's the Ministry of Justice, it's of course, the court, the European Commission of Human Rights, and you're very good at moving across sites and levels. And progressively, what comes out is a picture, a very complex picture of where the trajectory of European human rights is framed. And it's not framed only by the court. And the court, to some extent, is only, in a way, speaking, you could say, in the name of this collective that progressively emerges around European human rights. So that's the first reason for which it's very important for us as a lesson, in a way, for the current times. It's not only courts that save human rights, I would say, and we should not only focus on courts when we focus on how the health of human rights in Europe in particular. The second reason, I mean, that is really about, you know, the book is that you show how human rights are in a way a contingent and open-ended matter that it can go for the best and for the worst, actually, and it's not enough to say human rights to think that we're progressive and, you know, we're thinking about a progressive goal. You show very well how human rights could be compatible in the early 50s with the imperial project of the kingdom, as you say, and it could actually have exclusionary function to a certain extent in terms of civilization of European values. And you show also how much legal and political energy it took, in a way, to disentangle human rights from that imperial project and re-entangle it with democracy, in a way, with a more emancipatory narrative. And that's extremely interesting, I think, and very rarely told, I think, that, you know, it's not a story of rise and rise, or of sleeping beauty, as you say, but it's a story of conflict. It's a political story of how the framing of human rights and its political framing has changed over time. So I don't want it too long, but that is a way to say that it's very timely as a book. It helps us understand, the current discussion around human rights. It's not only a matter of courts. It's not, it's not. It's also a story about political conflict or across society. So, of course, it helps complexify, of course, the current narrative of backlash, I think, by many standards. But of course, I have a question. I mean, I think probably my colleagues will have the same one. Sorry to come first. No, but I mean, your description of the 1950s is really a beauty, and I have to say also in praise of your style, the concision and the quality, which makes everything very easy and nice to read. but I mean, and so the discussion, I mean, how much of the 1950s and the current context actually compare? I mean, we see the same sort of conflict between a civilizational understanding of Europe and a more constitutional, liberal understanding of European values. And many of the arguments that you unearth through the archives sound very familiar to our ears of today. So, what sort of theory of history do you have in that? I mean, is it is it that the archive is still around and somehow is just reopened? Which it would be frightening to a certain extent, but or to what extent is there something new in the current backlash or the current legal arguments around human rights and this conflict between exclusionary and inclusion and emancipatory understanding of human rights, and I think both actually are in conflict in a way still today. I will stop. I have 2 minutes or 1 minute?
1 minute.
1 minute. It's okay. Yeah. No. Well, in a way, the other question is I mean, it's a Dutch European history. There has been also French European histories. So my question in which a little bit is not that much developed in the book is somehow the transnational history of that. The extent to which governments are coordinated, in that story. I'm asking this because of the recent letter of Meloni and 7 or 8 governments that, in striking terms, even for your story, I think there's remnants and resilience of arguments, which is extremely impressive in terms of European value, particularly. But here we see something about a coalition of governments, and I was wondering, and it made me think, but doesn't really come out that much in the book, and so in a way, what about governments coalescing and to what extent is it still? I mean, is it pertinent to your story? I will stop here because I don't want to take too much time. But again, compliments. I'm really happy I was part of the trajectory of this book and in a very modest standing. But I've had the pleasure to read it early and okay. Well, I hope the best for the book.
Thank you, Professor Fauché. The next to speak is Sabine Meyer. You can stay seated or you can go. Yes.
As well.
Perfect.
So hello everyone. Do you hear me? Yeah. So for me, it was really a pleasure that Vive asked me to be here and discuss his book, because I think the book, Vive, is a beautifully written piece. And what happened to me when I started reading it, it was so nice because at the moment I'm teaching, grading, and I had the possibility to read this book in the middle of it. I simply couldn't stop reading. And as an academic, one has to read a lot of texts that are actually sometimes not very enjoyable to read. But when I started reading Vive's book, I started observing myself what I did, and what I did was to pour myself a cup of tea, to put up my feet on the couch, and really just had a good reading time. And that's usually what I do when I'm just having a lot of pleasure reading a book. But the book was not only a pleasant read, very well written, but opened really a new perspective to me, because the focus of the book is in many ways, I think, much bigger than what it proclaims. So it proclaims to be a history of the Strasbourg Convention through the perspective of the Netherlands, or from the perspective of the Netherlands, and it certainly is that, but I also think it's more than that. It also reads, and that's a little bit what we just already heard, it reads like a history about the changing meaning of fundamental human rights in the Netherlands, and that's what makes this book so enormously important today. And having said that, I have now 2 comments on the book and 1 question which is a bit similar to what you were asked, Antoine, but I will nevertheless pose it. First, I want to say a little bit about the framing of the book. Second, about the method that Wiebe is using in the book. And second, I have a question on the meaning of human rights today. Now, first, on the framing. In the introduction, Wiebe, you explained that you want to account for the success and the activation, how you call it, of the Strasbourg Convention. Not from a top-down, as he says, perspective, but from a bottom-up point of view. So more specifically, what Wiebe wants to do is to understand the success of the convention, not through a top-down legal perspective, the sleeping beauty, looking at the activism or the jurisprudence of the Strasbourg Court, but what he wants to do is to understand it from a top-down socio-legal point of view, looking at the engagement of legal actors, lawyers, institutions, and how they have activated the convention within the Netherlands. And in your own words, I think you phrased it very nicely, Wiebe, the book is less about how the law developed through judicial interpretation, it's about how the law was mobilized by particular individuals. However, I have a little however, what somehow remained unclear to me is why in this framing of your project, you require the Dutch perspective as the central lens. And this is really just about framing and in no way to question the historical analysis, which is very rich. So the introduction does read a little bit as if the Netherlands are used as a case to illustrate the broader success story of the convention through individuals mobilizing it. But when actually reading the core historical analysis of the book, I think your book is really more than that. It's a story about the changing meaning of fundamental human rights, as I just said, in the Netherlands, against the context of the convention. And I think that this story could have been even stronger if it would have been framed more in relation to the national context. So rather than framing it as a Dutch case to illuminate the general bottom-up activation of the convention, it would be framing it as looking at the case of the convention to illuminate a distinctive development in the Netherlands. It's a different framing. It's small, subtle, but I think it's decisive. But actually, after now you introduced your PhD and the book, I also understood better what happened, what you had to cut out. Now, a couple words on methodology. After reading the introduction, I expected the core chapters to unfold somewhat a little bit differently in terms of focus and method. So you describe your approach as socio-legal, emphasizing your aim to trace really the engagement of individual Dutch actors in the activation of the convention. Yet the core historical analysis reads less as a study of these actors and more like a general history or more a general historical account of the convention's development from a Dutch perspective. So the role of legal agents in this historical analysis is important, but not as central as one might expect after having read your what your methodological approach is in the introduction. I think one reason why this happened is probably because of your decision to cover a relatively long historical period, which inevitably limits you in how deeply you can engage with the individual actors and their stories. Still, I think there is a bit of a tension between how the project positions itself methodologically, so as a socio-legal research focused on key actors in the convention's activation, and how it's executed as a history of the convention from a Dutch point of view that integrates these actors, but does not necessarily always make them the protagonist. But I'm curious to hear a little bit your reflection on that. And third, and this is really more a question than a comment, or even an invitation to the audience for a broader debate. What I found particularly fascinating in your analysis was how you explain and work out and retrieve from these historical sources how in the early post-war decades in the Netherlands, the embrace of human rights was not grounded in liberal individualism, but in a commitment to European unity and shared cultural identity. It was like, we embrace human rights because we are Europeans, and Europeans, they are in favor of fundamental rights, even if fundamental rights were not necessarily understood the way we understand them today. I found that you brought out so nicely from the sources. So, in other words, to advocate human rights once meant to belong to a certain community of ethics and values. And today it seems to be exactly the opposite. So to defend human rights often means to position oneself against established communities and shared values, to champion the individual rather than the collective. So your book just prompted me to wonder whether, and this is where Anton has actually asked a similar question, but the book prompted me to wonder whether we might be moving back towards this early understanding of human rights as a project not of only the individual, but of more ethical belonging and understanding. Now, I'm almost done. I began my remarks by telling you how much I enjoyed reading this book. And I just want to tell you a little bit how I finished reading the book. And that is by and that was by scribbling down notes and ideas for my own research. And that really happens for me only when I really read good pieces. It's never the difficult reads, but the good reads that stay with us and really make us reflect and think about our own work. And this is exactly what Wiebes' book did for me. And so my advice for the audience today is to also pour you a cup of tea, put up your feet, and read this really inspiring piece of work.
Thank you, Sabine. Next to speak is Lynn Hillary.
I'll put this up a bit. Well, thank you so much for also inviting me. I was very happy to be invited and to be here at wonderful SPUI25 to discuss the Convention and the Kingdom, a title of which I'm still in awe. Given the time, I'll keep my compliments short, but I completely agree. It's such a well-written book. It was lovely to read a less legal writing style. It really read as a story, which is interesting because it's about narratives. I really enjoyed the fact that you displayed all of the... Oh, bit lower? Yeah? Okay, good. I really enjoyed the actors that you included, especially academics. I think Wiebe and I have talked about this, and I think it is really important, also looking at all the academics here today, it's really important for us to really take this as motivation to keep going forward and take a role within society. But of course, it made me think about my own work as well, same as with Sabine, which is in migration law. And Wiebe frames really nicely that migration law is quite an exceptional field of law within the convention. And my first question to you, and I think I know the answer and I think we agree on it, but just want to hear your thoughts about it a bit further. Do you think that migration law is actually an exceptional field of law, or do you think it's made exceptional, not necessarily by the convention, but by the court? Or do you think it's made exceptional by the states or other actors? So I'm curious to hear your thoughts on that, because especially if we look at what happened in the 1980s, as you described really well, that was the first time when case law of the court really came into being within migration law. And it's interesting that before that time, human rights and migration law were not really seen as fitting together, especially if we look at the case law today. Migration makes up such an important part of the case law. But interestingly, I think we see bits and pieces of that framing of migration law as not really being part of human rights still today. For example, the court still regards migration as the prerogative of the state. And while exercising that prerogative, states have to respect human rights. And this is vastly different in the way that the court usually approaches human rights. The state has to respect human rights, and that's the starting point. So it's a very different starting point of the assessment. And yeah, it makes me wonder, is migration law and refugee law specifically really so different from other fields of law, of other fields of human rights law? And if not, who is this shaped by? And it was mentioned a couple of times, this idea of pushback. And I think this also relates to what we see happening now within the field of migration law. You mentioned the letter of Italy and Denmark, also signed by a bunch of other states. And if you allow me to quote from this, because I think it's very telling. We believe that the development in the court's interpretation has, in some cases, limited our ability to make political decisions in our own democracies, and thereby affected how we as leaders can protect our democratic societies and our populations against the challenges facing us in the world today. We have seen, for example, cases concerning the expulsion of criminal foreign nationals, where the interpretation of the convention has resulted in the protection of the wrong people and posed too many limitations on the state's ability to decide whom to expel from their territories. End of quote. Again, we see that this migration context is a space of contention, not only with regard to the protection of individual migrants' rights, but perhaps unpopular individual migrants' rights, but also, and perhaps more clearly so, as regards to the role of the ECTHR and the convention itself and human rights protection in European states, both throughout history, as Wiebes' book shows, and also today. And so I will not ask you a question about the coalition of governments, but about democracy and human rights. Because looking at the case law that you describe and the narrative that has been developed, but also looking at more recent case law, I've been under the impression that the court is actually trying to protect human rights for the sake of democracy, rather than for the sake of individual rights protection. So my question is, do we view rights in the convention as individual rights, or as rights as the part of a democracy toolbox? So in other words, is democracy a conditio sine qua non for human rights protection? Or would you say that human rights are a means to ensure democratic governance? And this is not purely a theoretical thought exercise, as the Danish, Italian, and other member states' letter shows. Because if we view democracy as the starting point and as the most important thing, then surely we can limit some individuals' rights if it causes us to have a more democratic governance. On the contrary, if we view human rights as a starting point, individual human rights protection as a starting point of why the convention exists and why the ECTHR exists, then surely we cannot limit the rights of even unpopular migrants for the sake of democracy. And for the sake of time, I will leave it at that, I think. Yes. Thank you.
Thank you very much, Lynn. I think it's only fair that we give Wiebe the right to respond to some or all of the questions.
There were many.
There were.
But I think you can sort of weave them together in a way. So it's about continuities, it's about sort of these transnational collections of states, it's about also what the court does. So I'm going to begin somewhere. I'm not sure where I will end up. But that's usually how it works. So to maybe begin with this, make it a bit broader. So taking this sort of longue durée vision of the convention, and where can that sort of lead us now? So we move from a civilizational understanding of human rights to a bit more individual human rights protection, in particular in the 90s, and now we have a very strong pushback from a variety of states, and it all relates, I would say it almost all relates to migration. And I think there we have something interesting. So that makes migration already an important field of law, which is different from other fields of law, precisely because that's such a sort of politically salient issue. which has been made politically salient because the court has been doing this for quite some time and then no one cared. So this became a special thing, in particular in the 90s and early 2000s. That's where you see these first pushbacks. It's exceptional in the way that maybe more than other fields of law in the convention, you can really feel the colonial legacy. So the Strasbourg reversal you mentioned, where the state is the beginning, it's no coincidence, and I sort of briefly alluded to it, that sort of, yes, in the 80s we get these court cases, but there were court cases before that. They just were not successful. And one of them is the East African Asian case, which was dealt with by the European Commission back in the day, which generated ginormous amounts of pushback from the UK, which was deeply felt in that system, and afterwards the court didn't touch it again, out of fear as well of this pushback, I would say. So it becomes, it's one of those fields where the political saliency of it is deeply, deeply felt, even in the late 60s when the East African Asian case comes up. So yes, it is important there, because it goes way deeper into the state of prerogatives than, in a way, sort of how does one treat slightly less salient topics. So on this coordination of states in the system, I can see that this is very much a national story, but there are moments where you can see these connections come up. I'm thinking of a couple of examples. We have the convention as a tool for communal, I would say, activism, where with the Greek case, where a coalition of Dutch and Scandinavian countries used the convention, which is very much a first in a way, to protect democracy. Also, before that, you have these weird interstate complaints of Greece against the United Kingdom on Cyprus. But I think that's one part of this sort of transnational mobilization, which relates to bottom-up, but also the states themselves. Think also, and this is maybe where sort of I'm bringing also the 50s and the uniqueness of the moment in, there is a widely shared early pushback at the end of the 80s, where a variety of governments, pushed primarily by the Swiss government, aim to limit the system. They don't succeed because then the Berlin Wall comes down and there's a new narrative on human rights. But this sort of early sort of pushback against the system is very much something of the late 80s. If I would have asked you in 1988, do you think the convention will become this permanent court, you would have laughed at me. Absolutely not. So there you can see these sort of transnational things we now see with this letter very much in existence there, where you have the Brits very much against the Swiss, and they talk to one another to really sort of limit this system. Is sort of, then there's a continuity between the 50s and now in civilization. I think it's a different kind of archive which really sort of has a continuity. So civilizational language has a very deep structure. It's a very deep layer of understanding that we Europeans tend to be the fundamental right civilized people, also mostly white, by the way. And this is something you can sort of see pop up in discussions. So in the early 2000s in the Netherlands, you get people like Frits Bolkestein saying, well, using human rights, we can measure our own civilization. And, oh, look, we're doing actually better than they are. So there's this deep trope of civilizational thinking there, which is a continuity in a way. But if you look at sort of the system and how it works as such, it's obviously markedly different because the court is now much more engaged. So aside from this deep sort of civilizational continuity, I think this the systemic element is very much that of the late 80s, actually, right? Where you can see these transnational groups coming together and trying to limit the European court. So now we have a protocol on migration, maybe then there was a protocol on Article 6 that they wouldn't sort of interpret Article 6 anymore. So there I can see actually parallels, which was changed fundamentally by the end of the Cold War, but that to me is a very strong, more thematic connection. finally, maybe because, like I said, I didn't really know where this was going, but I'm moving ahead. So Sabine, on your points on mobilization, I think I agree with some of them. I know I'm talking too long, Jacob. Then maybe a sort of very obnoxious answer is, I'm not sure if I do social legal research. I think it's a historical study, right? Which is a sort of get away out of jail free card, sort of, no, I'm not sort of bothered by the methodological considerations of the social legal scholars, because what I do is in a way linking intellectual and social history. So it is more historical in that sense, where the law is then an object of historical study, maybe more than a very deep dive, methodologically even, into the mobilization of law. For me, it's very much about who receives the law, which can be mobilizing, but it can also mean leaving it aside, so not using law, which is the opposite of mobilization. So I think in my concern, actually, it's a bit bigger than that. It's by reception, which can be mobilization, but it can also be just not doing something, which happens in migration with the 4th protocol, which is actively kept at bay out of fear of a sort of colonial legacy. I think I've sort of gone through some of them, not all of them, but
yes. So thank you, Wiebe. So we have an outstanding and top-class panel on Europe and European law here. And before we go to the Q&A with the audience, I want to jump at that chance and have a question for the panel. I know something a little bit about research into the history or prehistory, if you want to call it, of the European Union. And my question to the panel, how does that compare? I mean, you call it a historical study. How does that compare to the history of the European Convention? So I know the European Union, at least to some extent, tends to curate and write its own history. For example, via landmark cases, but also by other means. European Convention, I think, has a relative lack of landmark cases. Do they write their own history in their case law or otherwise, or in relation to national courts?
this was a question to the panel. So, maybe I could just chip in. In a way, they do. This will be very nuanced and boring, but so you have phrases which continuously pop up: living instrument, protecting rights which are real and effective, so not theoretical and illusionary. Those are tropes which always pop up, which gives a certain mission statement to the court as well. So that is, in a way, ahistorical. So it's future-oriented. It's about the granting of rights to individuals. But it also means their history begins in the mid-70s. With Tyrer, with living instrument doctrine, and that in a way separates the court's narrative in its case law from its past. If it really builds this sort of unique narrative of history, I'm not so sure. I find it a very difficult question. I know Lynn has the better answer here.
I'm not sure I do. I just wanted to jump in and hear your thoughts on this. Would you say, Wiebe, that the main difference maybe in narrative is that the convention is quite often brought forward, and I think your book proves us wrong there, but quite often brought forward as something apolitical. It's done to protect human rights in the wake of the Second World War, whereas of course the EU was started as economical cooperation, and then, you know, because it was weird to do that without human rights, they got included. And I think maybe that's, in terms of human rights protection, I think maybe that's a very different narrative.
No, absolutely. So I think that's sort of, it's not necessarily, it is a question the court puts forward, but maybe not in its case law. So there was a war, then Europeans came together, decided no more war, we do that by human rights and happily ever after. It's the Sleeping Beauty narrative in a way, where the convention is the beauty as an answer to the horrors of the Second World War. It's in many ways an idealized version. You can see it with the EU as well. So if there was war, then we decided to pull resources, internal market, no more war. But the moment you do that, and obviously that's sort of part where the book tries to sort of unsettle certain narratives, it's not a rise and rhymes, one thing, and it's not necessarily a beauty. Right, so it can be both things. It can be sort of colonial, civilizational, and very much, I mean, there was still wars ongoing when the convention was already in place. Think of Algeria, they just decided to keep the convention out of it. But think also from decolonial violence in Kenya, where the convention actually applied, but there was a state of emergency, so they tried to keep it out of it. So by sort of breaking that history open, I think you need to unsettle that narrative of peace, because it's such a sort of internal European narrative, and even internal European, it doesn't really make sense.
I have a lot more to ask, but I do want to give the audience the opportunity. So this microphone will come to the person asking the question. I would ask the person asking the question to state their name and their affiliation, and in as much as they are comfortable. And if they're addressing the question to a specific person in the panel, to obviously name that person. Thank you.
This is always a very intimidating moment, I know.
Who takes the first bitterball, right?
Thank you. But I can do that. Thanks. Okay, all right. Okay, fine. Thanks again, really, for this fantastic panel. And Wiebe, congratulations once more. Really, I look forward to reading the book. I haven't read it yet. My first question is that we are all super intrigued by the title of the book. I think it's a fantastic title, no doubt about it. But I'm also quite intrigued about the subtitle of the book, right? And it is about how the Netherlands received the convention, right? So it's a story of reception at the end of the day. And I want you to sort of tell us a bit more about what that story is, because so far from the talk, it felt more as a story of sort of how the Dutch sort of contributed in its many ways to the convention, and it still does, but how did you receive it? What did you mean by that? That's one. The second thing I was wondering is that the word kingdom, right? I mean, how... Now, changes in meaning was a theme in your talk, right? So how was sort of the kingdom perceived in the 1950s and in 1945-50 when the convention was being drafted, but also in the 1970s when the Dutch still had colonies, right? So I want you to tell us a bit more about how the kingdom was perceived during that time, then in the 70s, and perhaps now in the light of decolonization. Thanks.
So I changed the title from what used to be co-creating human rights, where I presented reception as a fundamentally sort of active process. So reception to me is not a passive state of affairs where I just sort of receive the law and sort of, oh, the law. It's deeply sort of interactional. So to me, reception is an active process which is very much creating, right? So my initial title, co-creating European human rights, actually sort of captured that dynamic a bit better. But then it wasn't just about reception of law, it was more than that. So I see receiving law, so be it international, European, as deeply interaction. So you do something with that, and by doing something with law, you make it really into something different. So there are local meanings of European human rights law. There are people who have certain visions of it, and then they respond to European developments and they make something new out of it. So it's always about sort of this process which you get when you receive law. You're not just a passive recipient, no one is. It's a creative sort of active process. So maybe that's where this story, which is very sort of about creation, comes from, because it is. Changes in meaning of the kingdom, and I think that's a very good question. What you see happening in the 50s is a deeply felt distrust in the colonies when it comes to European integration. So there are two sides of the coin to not extending the European Convention, for instance, to Suriname, to the islands in the Caribbean. The Dutch state wasn't very keen on it, but also people in Suriname were deeply concerned they would be caught up in a European integration project to their own detriment. And they knew this could happen because that was very much a reality with the Plan Strasbourg, which was developed also in the Council of Europe context. So there the kingdom to Suriname, for instance, was a threat of being involved in European integration against their will. This changes somewhat in the 60s and 70s. In particular, some people in government change. The idea of European integration becomes a bit tricky. You get European Development Fund, which is, it's not great, but people are keen on getting these kind of development monies. And then, so Suriname changes its disposition, but also the islands in the Caribbean. They see getting sort of caught up in the European integration as also a source of remaining, in a way, in the kingdom, and in doing so remaining safe, in a way, because remaining in the kingdom then to them has become something different than just a threat. So there are changes in meaning there, and this is a continuous, deeply sort of contentious issue, which still plays out today. So very, very, very few complaints ever reach Strasbourg from beyond Europe. Because, I mean, it's a very long process, it costs time, but there's also, it's far away. And there's also some kind of distrust still. There's a little sort of local, do they really want to do this? No, not really. So this plays out to this day, and then it's sort of a bit who you discuss it with.
I think it's really, there's this contrast with the Universal Declaration. So if you look at Sam Moyn's work on The Last Utopia, there actually is a huge influence on of the Universal Declaration on the decolonization process, because the human rights were seen as, a call to self-determination. And that did not happen at all with the European Convention, despite them having, the former colonies having the right to petition. Explicitly so, I believe, the Dutch colonies, if I have read the chapter correctly.
So the Netherlands is in a way unique, so this brings us back to sort of also why the Netherlands. The Netherlands is in a way unique in, not just in extending the convention, other states do this, but also in extending the right of individual petition to Suriname, for instance, which is remarkable because other states don't do that. France doesn't do that, the UK doesn't do that, don't think about doing that. But then the question is, what happens? And very little, because there's some complaints. No one knows about these complaints, by the way, but they happen. So it's a unique moment where the European convention system is actually becoming more than a European system, because it's fully functional in Suriname.
In theory.
Yeah, in theory, but also in practice. I mean, don't get me wrong, there were very little complaints in the Netherlands at the time, but so it is being used unsuccessfully, but it's still there. So that's in a way a striking moment.
Sir, please. Then you, madam, and then you, sir. Yeah.
Thank you. Well, thanks for this wonderful discussion. I only want to make two comments, one small one and one somewhat longer. The first one concerns the question of migration law and the European Human Rights Court. I want to draw your attention to the fact that in 1998 we got a Council of Europe Convention on Nationality, and there the jurisdiction of the Human Rights Court was excluded expressly, because states did not want the Human Rights Court dictating the contents of nationality law of the member states. And the other side of the coin of nationality is foreigners. And foreigners is migration law, And there the jurisdiction and sovereignty of the member states is at stake as well. And that is why I think the court of Strasbourg thinks this is an area where angels fear to tread. That is my first small remark. The second one, I was triggered by the idea of mobilization of the human rights law and the interaction. And I have a case in point. I must say I was mobilizing the European Strasbourg Court in a matter of procedural law because I thought that the Dutch Supreme Court was trespassing in this respect and was not acting according to Article 6, Section 1 by introducing so-called reservist substitutes in camera at the discussions. You may be aware of the case. I wrote an article, I think 20 years ago, and then we had a discussion. I had a discussion with the President of the Supreme Court, and he didn't think it was necessary to have this practice enacted in an act of Parliament. And so we sought out a case, a small criminal case, to introduce this matter to the European Human Rights Court, then presided by Sifra O'Leary, whose supervisor I was with her PhD at the European University Institute. I draw your attention about interaction now. She started out at the European Court of Justice before she went over to the European Court, to the Strasbourg Court. But that's a sideline. Because what happens is indeed, at first we were laughed at for this case. It was frivolous, outrageous, and so on. But afterwards, the climate changed a bit, and then what happened is that there was a European Court of Justice case, Han Invest, and that implied some conclusions for the case on the Supreme Court case. And I think that triggered the fourth chamber of the Strasbourg Court to ask the Grand Chamber to deal with the question. So it's now become a serious question, and it is interesting to see that the Strasbourg Court has invited several agencies, the Venice Commission and others, to intervene because it is a serious question. We will have a discussion, a hearing on the 20th of January next year, and I think, well, then this is a typical case of, well, triggering the convention by a scholar, I may humbly say, and who is also an activist all his life, and now the court introducing all kinds of others to deal with the question as well. Thank you.
Thank you, sir. Wiebe, do you want to respond? Lynn, you might want to respond as well, I think.
Yeah, I think you saw that correctly, especially to your first point regarding nationality and it being the other side of the same coin of migration law. I think we see a similar thing, because I completely agree with you, and I think we see a similar thing happening within the EU, where the Luxembourg court, so the ECJ recently made a point of saying, well, Malta, I think it was, who gave out Maltese nationality if you paid enough money, the golden passport scheme, and said, well, you can't just do that. It is part of nationality. So the principle of nationality is part of the member states' prerogative, still stands, but we see that in nationality law too, it does become more of a European thing. That's of course not instigated by human rights, but by European cooperation and interaction too.
It was wrongly decided.
Maybe very briefly. So, yes, academics are important. And this is a very practical example of getting a case to Strasbourg, but this is how the first cases of the Netherlands came to Strasbourg. These were not just isolated individuals, these were being coached by engaged academics who knew how the system worked and were trying to get it going. So it's a very old tradition in a way.
Madam.
Thank you, and thank you so much for the presentation and the talk. Very inspiring. I'm going to introduce myself. I'm Clara. I'm a colleague. I'm a PhD. I think you asked that initially. I'm not sure how to phrase the question. Part of it is how Dutch is the story, and could you maybe place this relationship between the convention and the kingdom into the overall context of Dutch law? That sounds very broad. But I was also thinking in terms of the fact that international law in general has direct effect and the way it is received, but also the fact that this country has a weird relationship to a constitutional court and not having one. How do these puzzle pieces play into that story that you're telling?
It is a very Dutch story, but it's also more than that. So yes, I think that it's a super Dutch case, and the Netherlands are specific precisely because of the sort of constitutional openness to international law, which allows for sort of a big amount of reception to take place. I think in general, however, if you look at sort of how this works, it's very comparable to, for instance, the Scandinavian countries. I mean, Antoine, I think you also read the Pauline Bonino's work on France. Maybe you can say a bit more on sort of similarities in the French system. But, I mean, yeah, so there is this sort of, it is a uniquely Dutch story, but the challenges, in a way, colonial legacy, who gets to mobilize European human rights, with which reasons, they are very similar, I think, to a lot of signatory states in this sort of early Council of Europe's context. And I can only hope that sort of more study of this kind will now emerge, because, I mean, there will be similarities, but there will also be differences. Yeah.
Yeah, yes, very, very briefly. But I mean, it's true that your work, your book gives the impulse of engaging a sort of comparative study of national varieties of European conventions of human rights. It makes me think of an article of a colleague, Bruno De Witt, on EU law, and it was looking at how EU law was taught in various countries, member states, and what sort of bibliography, how it was taught, how it was organized in teams, and you could see that it was filtered through national legal culture, obsessions, contexts. And in the case of France, that you mentioned that a good PhD, Bonino, worked a little bit along the same lines, but with different. But anyway, but she has she points very much at the fact that the reception of the convention in France was heavily influenced by the birth of the Fifth Republic in '58. And the idea, I mean, I talked about this earlier at the university, but the idea that it was clear that it should definitely not impede the Gaullist power to engage its revolution in a way. So it means keep Algeria in France. It meant, avoid the exception of exceptional powers that de Gaulle had put in the constitution. And, it also the issue of secularism. I mean, a whole set of issues that were considered too sensitive for France to enter the. So in a way, it was completely filtered through the big legal obsessions of French legal culture of the time. And I, in a way, I don't know to what extent it's maybe bouncing back to you, but to what extent would it make sense to engage in a comparative work of this type, and what can we hope for from this? But maybe it's for later.
Yeah, just a small addition to what has been said and to your question. And I'm in a way now speaking for you, but I just read the book. I have it all fresh in my mind. I think it's a very Dutch history that you write, but as I said also in my presentation, I think it's just really more than that, because there are cases that you describe which I'm sure happened in similar ways also in other member states, and we were talking about it. So one of the we had a small conversation about this a couple of days ago. What I found very interesting is that at the beginning, there were a lot of cases that arrived at the court concerned to religious issues. So one example is, for instance, the Netherlands started to establish a welfare state, a pension system, a new thing. And that meant that everybody had to pay in equal amounts into the pension system. That meant also the priests had to pay it in. But the priests had their own pension system with the church. And there was a case that arrived before the court asking whether this is right, that also the priests were sort of obliged to pay that pension. Or what you actually described so well, which I knew about a little bit but not in depth, is this religious tension within the Netherlands between the north and the south, the Protestants and the Catholics, and how the Catholics were not allowed to have processions for a very long time. And one of the reasons, if I understood you correctly, was that the Netherlands were so hesitant with regard to the convention for a long time, exactly because of that law. No? They wanted to keep that prohibition of for the Catholics, that they are not allowed to proceed in a religious way. So this is just to give you some examples that for me were fascinating, but because they're very Dutch, but I think if we would dig deep enough, we would find a lot of parallel examples probably in other member states.
I'm still waiting for the Dutch version of the Lautsi case, where we're forced to define Dutchness at one point or another. So, sir, yes, yeah.
Thanks. I'm Piotr Kajewski. I'm Wiebes' colleague from the Department of European and International Law at the UFA. So just want to say that I'm delighted by the fact that you contribute, Wiebe, to destroying the court-centered narratives around human rights law and EU law. That being said, apologies if the answer is in the book, which I haven't read yet, but in your historical research, have you found an example of a judge of the Strasbourg court who would fit perfectly in the court-centered narrative? You know, somebody who by reasons of biography we can tell was an activist judge who developed maybe some groundbreaking concepts and actually maybe changed, you know, the trajectory of the development, you know, like a Pierre Pescatore of the conventional law. Thanks.
Yes, to be very concrete, I don't say courts do not matter. They matter greatly. I'm just saying they're not the only ones that matter. So, are there sort of judges which are very important? Yes, obviously they are. Both on the European level as on the domestic level. And more often than not, they coincide. So, just to take one example, we had a Judge Viarda, who was the sort of icon of private law in the Netherlands, absolutely impeccable credentials. Head of the Hoge Raad, moves to Strasbourg and becomes very, very critical of one certain element of the Dutch constitutional setup, the Council of State, and says, well, this might be in violation of Article 6 because this is not an independent tribunal. The fact he lends his personal authority to that finding, which French could maybe do in this situation, to bring it back to earlier today, but the fact that he does that has a tremendous impact in the Dutch constitutional landscape. Because if someone like Viarda can say something like that, it means we have to take this weird convention, which no one cared about, seriously. In the alternative, there are many sort of judges, and this is a broader development in, for instance, let's say family law, where the development of family law is deeply sort of court-driven in the Netherlands, where it's the judiciary itself which uses the convention and sort of the family law element there to really open up Dutch sort of family law. So it moves from a very hesitant sort of reading of family law into a very expansive reading of family law, and it uses the convention in that. That is court-driven, very different from other fields of law in a way. So yes, courts are important, and yes, there are deeply important individuals there. It's just that sort of you can't explain everything through courts. So if you look at migration law or, well, then it becomes much more interactive, and then the courts really follow.
So if there are no questions, I have another question for the panel as a whole. So particularly reading the chapter on the defining decade, I'm very much struck by the topicality of the book. So this is not a history, an irrelevant history. This is a history that in many, many points is highly relevant to a lot of problems that we have today in Europe on the national political level and with regards to the application of the European Convention on Human Rights. So particularly Article 8 and Article 6 for the Netherlands are to be singled out, but I think for various countries there are other articles that are problematic. Then my question is to the whole panel: can we relate the history of the European Convention as it has occurred, as it is known in this book, to current problems that we have internationally speaking and on the national level? A simple question. A simple question to.
Yes, I do expect some help along the way. Yeah? Yes, that will be the short answer. So the history matters here. Because it helps us to see two things. One, pushback isn't new. Pushback has been a fundamental staple of this entire system since the beginning. And I think it's only in a rare moment in time when there is actually support, in the mid-70s and in the sort of early 90s, where states actively come out and say, this is fantastic, we need to sort of strengthen the system. Before that, I would say pushback or very critical, hesitant stance has been a staple of this system throughout. So pushback isn't new, it has always been there. It's been there very prominently from 2010 onwards with multiple sort of intergovernmental summits, the age of subsidiarity, procedural turn. It's all there. So it allows us to see that what we see now is nothing new in abstract. But we also, and this is maybe the other side of the coin, that what happens now is something new. That pushback was always aimed at sort of limiting the system, getting it back into its case. What we see now is a bit more fundamental even, I would say. So criticism from the United Kingdom on the convention has been very, very common. Oh no, those in Europe, they can't determine our laws, that's fine. But it's always in a way very sort of specific on cases. Now with migration, something new has happened, that the issue has become something which affects the entire system. So it's not just migration, it's the entire system of European human rights protection which is suddenly sort of thrown in the mixer there. And I think that is actually quite new. That this sort of pushback against everything, sort of, that is something I find is maybe not fundamentally new because you can see it before, but I think that's striking from different kinds of pushback we've seen, in particular in the last sort of 20 years.
I think something else that we see now that we, I think, haven't seen before is that human rights are also employed to limit other people's human rights. And I think that's something that maybe wasn't as prevalent as it is today. So I think maybe now we're in, or it seems to me that we're in a situation where protecting human rights and keeping the level of human rights protection where it is actually more of a conservative stance in a way than it is a progressive stance. Whereas I think your whole book is more about human rights as a means to progress the level of protection. No, maybe not.
Well, what I see also coming from your book, but also, from a comparison with EU law, is the fragility and contingency, hence also fragility of European human rights. And it's heavy reliance on, a series of support groups that really make it happen or not happen, and for the very organization of that type of law, compared to EU law, in which I think, in a way, it's much more ingrained through the market, in national legal systems than the human rights system, which still is perceived and received as a foreign law, I would say, much more than EU law is today, for a large part. So in that sense, I see diverging trajectories to a certain extent between European human rights and the court, and European law and its own court, and not in a good way for Strasbourg, but that's also.
So I think Wiebe shows particularly the involvement of non-government organizations in that defining decade, that at least once upon a time, to stay in the terminology of the book, it was seen as something that belonged to us, that was there for our protection, and that was in conjunction with democratic values, where I think nowadays, I don't know if it's a recent or longer development, but nowadays there seems to be a bit of a struggle between democracy, the will of the people, and fundamental rights as worthy of protection, especially those of minorities. Do I see this correctly?
Maybe before I answer the question, I had another comment on your previous question. Yeah, thanks. I had another comment on your previous question, and it's difficult to answer the question because it's the question I asked actually in the presentation to Wiebe, but nevertheless, you didn't answer, yes?
I heard that too.
So I think and this is again praising your work, what I sometimes miss in today's fundamental rights debate is that it's often very flat, in the sense that we praise the right for the sake of the right, for the sake of the individual, the autonomy that we perceive to inspire it, and we don't go deeper. And when I say we don't go deeper, I don't mean looking at the interests behind the rights or looking at them as sort of a means for certain strategies or powers that we want to reach. I mean really the social context, the value context. I miss that often in the debate today, and I think it also doesn't do us very well, because it makes it often also not very understandable to many people what are the fundamental rights actually about. And that I liked about the book, and the question was also how can the book contribute to today's debate, and what we're experiencing is to get back to looking really for the values, the ethics, the society underlying a right, because I do believe that it's not rights against society. The society is the value is a part of the right itself. And somehow I think we need to combine these two again in our debate nowadays.
At the same time, I think that's the funny thing about the 80s, which I labeled the defining decade, because everything sort of very important happens in the 80s, at least when it comes to the convention. Maybe also other things, but there you can see this change occur actually, where sort of rights get increasingly drawn into the legalized narrative, where also the NGOs who were in the 70s, the sort of mass movements, everyone was on the streets having sort of chants, etc., they become professionalized, and that means they're very much they become more governmental focused in a way. And their language changes. So they move from narratives to rights as such. And I think that's this is an in many ways, it brings it back to the 80s, where this is hugely successful. The language of rights is extraordinarily successful, and it really kicks off in the 80s. But you also lose something if you just speak about rights in terms of rights language, in particular when it comes to just legal rights language. So that's maybe something to blame the 80s for in a way.
So excellent. I'm looking around the room one last time. This is your chance, ladies and gentlemen. Right. Yes, sir.
No, because maybe that's a nice tie-up to the discussion about the colonial legacies of the convention. Do you have an opinion? I mean, I'm not forcing you, Viva, to have one on the EU's accession to the ECHR and the colonial context of the history of both, ecosystems, so to say. Thank you.
A strikingly difficult question. To be fair, I mean, there are topics I have strong feelings about a lot of topics. The accession of the EU to the convention is maybe not on that list. But I mean, I think it's telling in a way. So the EU, it's telling because it relates back to these different histories of the project. Both begin as European projects. So the European project in, let's say, 1947 is the Council of Europe. That is where European hopes and dreams are primarily focused. That shifts in the 50s to the more efficient, in a way more modern, economic Europe, so Community Coal and Steel, and European communities. That is then seen as the prime, if you take a look at the European integration NGOs, the European law, everything is focused on the EU. So they take up this mantle of European idealism from the Council of Europe, where everything gets dragged down into intergovernmental elements and nothing really happens in a way for a very long time. But obviously the economic Europe, to label the EU the economic Europe, has one downside, and that is that they don't do human rights. So throughout the 50s, 60s, 70s, that's a challenge. They don't have a human rights charter. The court tries to make one through case law, but it's all connected to the market in a way. If I were to be very idealistic, I would say that accession would bring those two tracks of European idealism from the 50s back together. But that would be the very idealistic me. In many ways, they have existed so long, they have become very different animals. Whether that would have an impact on colonial legacy, etc., I'm not so sure. Both have their own very different legacies of colonialism. There's just a book which has been published on the colonial legacy of the EU as such. Again, that's very much market-orientated, but it's broader than that. So those histories are similar, but also very different. That's not the legal issue when it comes to accession, but this is a very long, winding answer to say I don't really care. Would it matter? Yes. Fundamental rights protection, obviously. Do I have very strong opinions about it on the basis of this book and this research? No, not really.
Sorry. We have found something Wiebe does not have a strong opinion on. I think this is also a worthy closure of this session. Will you please join me in thanking our panel? Excellent panel. Thanks. And thanking Wiebe for his wonderful book and his excellent presentation.
There will be drinks.
Yes. Yes. Thank you all.